Good morning. Welcome to Families First Coronavirus Response Act Update, Part 2. Today's presentation is brought to you by the Fargo-Moorhead West Fargo Chamber, and it's the second in a series of videos intended to give you information about the paid leave aspects of the FFCRA. Today I want to talk about the new federal regulations which came out after the first video was recorded, and some key takeaways for employers. If you haven't had the opportunity to watch the first video yet, which goes in depth into more of the basic provisions of the FFCRA, you may want to watch that video first. I'm Lisa Edison-Smith, and I'm an attorney with the Vogel law firm, practicing for 23 years in labor and employment law. And as all of you know who are watching this, the past month has probably been the most difficult that you as business owners and HR people have had in trying to deal with the just vast number of federal regulations, state guidelines, shelter-in-place orders, federal tax credits available to deal with the pandemic emergency that we're now in. I'd like to update based on the federal regulations and rules that came out, and they deal with the two aspects of the Families First Coronavirus Response Act. The interim regulations, as they're called, came out to address some of the details that we didn't have when we made the first video or when the initial statute came out. But just as a refresher, the FFCRA provides up to 80 hours emergency paid sick leave and up to 12 weeks, 10 weeks paid of Emergency Family and Medical Leave Act, leave related to the need for child care or school closure for dependent children. The statute, FFCRA itself, was effective April 1, but on the date that the statute became effective, only the question and answer guidance from the U.S. Department of Labor was available for you all to know what you were supposed to be doing. It's a little bit like trying to prepare a recipe without the recipe. The FFCRA questions are very helpful, and they're available at the link on your screen. They have also been updated since the regulations have come out, and some of them have actually been revised slightly. So they're a valuable source to go back to for you to look at questions and answers about practical things that might help you in applying the statute to your business. On April 1st, the U.S. Department of Labor unofficially published the interim regulations applicable to the FFCRA, which were published officially in the Federal Register on April 6th. The regulations themselves clarify a number of the issues that were unclear from the questions and answers and prior guidance available from the U.S. Department of Labor. Unfortunately, they don't clarify all the issues. Some issues are still in a gray area, and the Department of Labor continues to update its guidances and questions and answers to help employers determine what exactly do the regulations say. So as you watch this, remember the Department of Labor interpretations are still evolving. Before we get into the key takeaways from the FFCRA regulations themselves, I'd like to briefly review the main provisions of the FFCRA statute. The first provision of the FFCRA is emergency paid sick leave. Emergency paid sick leave of up to 80 hours is available if an employee is unable to work for a list of qualifying conditions. The second aspect is expanded Family and Medical Leave Act, and the expanded leave provides another reason for the taking of FMLA leave. It provides for leave of up to 12 weeks with the first 10 days or 2 weeks unpaid for absences required if the employee is caring for a son or daughter due to the closing of a school or daycare for a COVID-19 reason. The qualifying reasons for FFCRA are on your screen right now. The first one is if the employee is subject to a quarantine or isolation order related to COVID-19. Number 2, the employee's been advised by a healthcare provider to self-quarantine because of COVID-19. Number 3 is leave because the employee is experiencing symptoms of COVID-19 and is actively seeking a medical diagnosis. Number 4 is the employee is caring for an individual subject to or advised to quarantine or remain in isolation due to COVID-19. Number 5 is caring for a son or daughter whose school or place of daycare is closed or the child care provider is unavailable due to COVID-19. And number 6 is the undefined, the employee is experiencing substantially similar conditions. Number 6 has not been defined, and it was not defined in the Department of Labor regulations. The 6 reasons on your screen right now are all valid for taking emergency paid sick leave, that 80 hours of paid leave under the FFCRA. However, the only reason for taking expanded FMLA leave is when the employee is unable to work or telework because the employee is caring for a son or daughter whose school or place of care is closed or child care provider is unavailable due to COVID-19. And to briefly review the limits on paid FFCRA leave, if the employee is taking paid sick leave due to the employee's own illness or quarantine, the employee may be paid his or her, or must be paid his or her full rate of pay, capped at $511 per day, or a total of $5,110. If the employee is absent and using FFCRA leave to care for another, whether it's emergency paid sick leave or it's leave under the Expanded Family Medical Leave Act due to a school or daycare closure, the employee must be paid at 2/3 the employee's regular rate, capped at $200 a day, or $2,000 under the paid sick leave, or $10,000 total under the expanded FMLA. Under the expanded FMLA, the employee is entitled to 10 weeks paid for a total of $10,000, but the initial 2 weeks can be used with the emergency paid sick leave at a total of $2,000 for a total of $12,000. And there are exemptions. Exemptions that paid sick leave need not be provided for healthcare providers and first responders, or for small employers when the viability of the business may be threatened. Now I'm going to shift to the regulations themselves. What are the key takeaways from the regulations? There are 10 key takeaways that I'd like to outline today that I think are of great interest to employers, and many of them which run through all of the FFCRA requirements, whether the leave is taken for the individual himself or to care for another. The first key takeaway is the preeminence of telework. The regulations make it clear that telework and the ability to telework is a major concern in determining when an employee is able to take paid leave. Throughout the regulations, it's clear that employees are only eligible to take paid leave under the FFCRA if they're unable to work, whether it's at the normal workplace or telework. So telework and the availability of telework is very important. And the regulations define when is an employee able to telework. An employee is able to telework if his or her employer has work for the employee. So the first requirement is the employer has to actually have work that's available. Second requirement is the employer permits the employee to work from the employee's location. In other words, from the employee's home or wherever the employee is located, rather than reporting to the employer's job site. And number 3, there are no other extenuating circumstances. An employee is generally available to telework if the employee has available work at home, but there may be extenuating circumstances that prevent the employee from working, such as the employee may be too ill to work because of COVID-19, or the employee may be caring for an individual who is ill from COVID-19, and the amount of care that person requires just doesn't allow the employee to telework. Number 2, the second key takeaway is what's the effect of stay put orders? Well, the first available category of leave is for employees who are subject to quarantine or isolation orders. And there was some question initially based on the questions and answers put forward by the Department of Labor of what does that mean for stay put or shelter orders. And initially the belief was stay put or shelter orders wouldn't qualify at all under the first requirement of quarantine or isolation. And in the regulations, the Department of Labor has clarified that somewhat. And the regulations state that shelter-in-place or stay-put orders may qualify for emergency paid sick leave under reason number 1. However, it's really a limited application because an employee subject to a stay-put or shelter-in-place order is only entitled to emergency paid sick leave if the stay-put order itself prevents the employee from working or teleworking. So that's a shelter-in-place or stay-put order that requires the employee to remain home, that applies to the employee. It's inapplicable, and emergency paid sick leave is not available if the employer closes due to a stay-put or shelter order that applies to the employer itself. And it's inapplicable if the employer has no work or telework available for the employee. As an example, an employee may be subject to a stay-put or shelter-in-place order issued by the state, such as in Minnesota, and unable to go to work. However, the employee would not be entitled to emergency paid sick leave under reason number 1 if the employer itself was closed down because of the shelter-in-place order. Another example would be if the employee is subject to the shelter-in-place order and the employer is not, for example, a North Dakota employer, but the employer has no available work for the employee. In that case, the employee would not be entitled to take emergency paid sick leave even though he or she was at home and unable to work. The third key takeaway is when is leave available for self-quarantine or when the employee is seeking a diagnosis? What's really required for that? And the first key element, which is applicable to really all types of leave under the FFCRA, is the employee must be unable to work. That includes telework in order to be eligible for paid leave. So if the employee is able to telework, the employer has telework available to the employee can't elect just to stay at home if the work is available. What's necessary for the employee to self-quarantine? Well, an employee can't unilaterally decide, I need to self-quarantine because I've been exposed or I'm having symptoms that I think are consistent with COVID. The self-quarantine, in order to be eligible for paid sick leave, must be because of the advice of a healthcare provider. It must be based on that healthcare provider's belief that the employee has COVID-19, may have COVID-19, or may be particularly vulnerable to COVID-19. Fear of the illness itself is not sufficient. An employee who self-diagnoses without getting the advice of a healthcare provider that the employee is concerned or afraid to go to work, or even believes that they may have some underlying vulnerability to COVID-19 without consulting a healthcare provider, it is not a sufficient reason for the employee to be paid emergency sick leave. And what's required for an employee who's seeking a diagnosis? Well, an employee may take paid emergency sick leave for time spent making appointments, waiting for appointments, or attending an appointment for a test for a diagnosis of COVID-19. The employee may not take paid sick leave without seeking a medical diagnosis. Similar to self-quarantine, it's not enough for the employee, him or herself, to decide, I need to do this, I need to self-quarantine, or I need to get tested for this. If the employee doesn't follow through and actually get the healthcare provider's diagnosis. Employee who's able to telework may not take paid sick leave while waiting for the test results. So if the employee is at home waiting for test results, employer has available telework, the employee generally won't be available for paid sick leave unless there are extenuating circumstances. And the extenuating circumstances could be that the employee has serious COVID-19 symptoms and is simply too ill to work. Key takeaway number 4. An individual is defined. And what does that mean? One of the eligible reasons for leave is if the employee is caring for an individual who has been diagnosed or required to self-quarantine due to COVID-19. And the initial text of the statute didn't define in any way what is an individual or who is an individual that the employee would be eligible to take paid leave to care for. Limits on qualifying individual. Leave may not be taken for an individual with whom the employee has no personal relationship. And what does that mean? Personal relationship means that the person for whom the employee is giving care must be an immediate family member, a roommate, or a similar person with whom the individual has a relationship that creates some sort of expectation that the employee would care for that person. And these may be persons in the same household, but otherwise the examples are family member, roommate, or similar person. It's inapplicable as with other types of leave. Paid sick leave may not be taken to care for another individual if the employer otherwise has no work for the employee. So an employee for who has been laid off or subject to reduction in hours, even if the employee is caring for an individual with COVID-19, would not be eligible for emergency paid sick leave. Similarly, an employee who is able to telework and the employer has given permission for telework during a period that the employee is caring for someone who's required to self-quarantine or isolate would not be eligible for paid leave unless they were extenuating circumstances such as the individual for whom care is given is very ill and requires a considerable amount of the employee's attention. What's the 5th key takeaway? Well, this is a big one because a lot of questions came up after the initial text of the statute came out about when is leave available for childcare or school closing. Well, the regulations clarified that leave is only available for an individual when no other suitable person is available to care for the child in question. And leave is unavailable if another suitable individual, such as a co-parent, a co-guardian, or even the usual child care provider, is available to provide the care the employee's child needs. Many employees have asked the question, can I take expanded emergency FMLA leave when my daycare is open, but I'm simply not comfortable sending my child to daycare? And the answer is no. That the Emergency Family Medical Leave Act for child care or school closings is only available if the regular child care provider is not available due to a COVID-19 reason. The second key takeaway for leave for child care or school closings is that work must be available for the employee to perform. If the employer does not have work available for the employee, then the reason that the employee is not working would not be due to the closure of the child care or daycare and eligible for leave. It would be the fact that the employer simply has no work and the employee would not be entitled to paid leave. Secondly, the employee is not eligible for paid expanded family and medical leave if the employee is able to telework while meeting the child's needs. And that may be while co-parenting in shifts with another co-parent so that the child's needs are being met in shifts, or shifting telework to other hours of the day. The third critical issue addressed by the regulations is the age of the child for whom leave can be taken. The original text of the FFCRA simply referred to care for the employee's son or daughter who was under the age of 18. The regulations themselves, however, come out and clarify exactly what does that mean and what are the exceptions to that. And there are two areas of clarification. The first is that, yes, an employee may take leave due to the lack of daycare or a school closure for a child up to the age of 18. However, when that child is over the age of 14, the employee must show special circumstances that require that the employee take paid leave during daylight hours. And what are those special circumstances? The regulations don't define them, but one can imagine that a child with a learning disability, a child with some sort of emotional or other disturbance or physical disability may require additional leave, even if it's additional care, even if it's not during daylight hours. A second clarification about the age of the child for whom leave may be taken is that leave may be taken for dependent children over the age of 18, even if they're adult children, if they have disabilities. So although the text of the act itself said the employee's son or daughter up to age 18, the regulations have clarified that similar to regular FMLA, leave may be taken for adult children who are unable to care for themselves due to a disability. Takeaway number 6, and this is a complex area of FFCRA, because FFCRA for employers with 50 or more employers requires that you look at all sorts of available leave. It requires that you look at regular FMLA, expanded FMLA, expanded sick leave under the FFCRA, and also how does that work with the employer's own paid sick leave policies. And the regulations have given us some guidance on that, although there are some gray areas that remain to be defined. The first clarification, or I guess point of emphasis, is that emergency paid sick leave, that 80 hours of paid sick leave, is in addition to and not a substitute for other paid leave. So an employer who regularly would provide the employee 2 weeks of paid leave cannot say your 2 weeks of paid leave is substituted for the emergency paid sick leave. Rather, the 2 weeks of paid leave due to the employer policies is on top of the 80 hours of paid sick leave, and the employee would have potentially 4 weeks of paid sick leave available. Another clarification is that the paid sick leave under FFCRA is not retroactive. So many employers began providing leave to employees prior to the time the FFCRA, was actually in place on April 1st. If the employer provided, for example, 2 weeks of paid sick leave because of the employee's illness or quarantine prior to April 1st, that's not eligible for FFCRA leave, which means two things. It means the employees on April 1st is entitled to a full 80 hours of paid sick leave for qualifying reasons, even if he or she took leave of 80 hours or more prior to April 1st. The other thing that it means is that for those employers who provided paid leave prior to April 1st, there's no federal tax credit available for providing that paid sick leave. When dealing with the expanded FMLA available under the FFCRA, the regulations also provide us some key guidance on how does that leave taken under the expanded Family and Medical Leave Act relate to leave taken under the regular FMLA. And as you probably know, the Expanded Family Medical Leave Act under the FFCRA applies to all employers under 500 employees, not just those with 50 or more employees. But for those of you who have 50 or more employees, the question remains, how does that leave coordinate with leave the employee may already have taken under the FMLA? And the new regulations make it clear that the Expanded Family Medical Leave Act emergency leave for childcare or school closings is a new category of leave. It's not leave in addition to regular FMLA leave that an employer has to provide. And what that means is that the leave may be reduced for regular FMLA leave already provided to the employee in the prior 12 months. So if, for example, an employee works for you and has already taken 4 weeks of FMLA leave under the regular FMLA for employers with 50 or more employees for his or her own illness, the 12-week leave availability under FFCRA is reduced by those 4 weeks. So the employee would only have an available 8 weeks of leave. Another key clarification is that the paid sick leave that's provided under the Emergency Paid Sick Leave Act portion of the FFCRA runs concurrently with the FMLA leave, the expanded FMLA leave, that is. So an employee is entitled to 12 weeks of expanded FMLA leave for childcare and school closings, and the first 2 weeks of that may be unpaid. But the employee may substitute the emergency paid sick leave for those first 2 weeks. If the employee does that, the employee is still only entitled to 12 weeks of total leave, and those first 2 weeks that are substituted for the unpaid leave count against the 12-week FMLA entitlement. Another key takeaway is, when can paid leave be required or used by an employee when the employee is caring for another? And this is in the case when the employee is only receiving 2/3 paid leave because of the limitations of FFCRA, which would apply to the Expanded Family Medical Leave Act for child care or school closings. An employee is entitled to 2/3 of his or her regular pay at a cap of up to $200 per day. It would also apply to that portion of the Emergency Paid Sick Leave Act, which applies when the employee is taking that 80 hours of paid leave to care for another. In that circumstance, the employee is only entitled to be paid at 2/3 his or her regular rate of pay up to $200 per day. So the issue then becomes, may the employer require the employee to exhaust available paid leave under the employer's policies to make the employee whole? So if the employee is receiving 2/3 of his or her pay, may the employer say, you're required to use your available sick leave before you can take unpaid leave for that additional third of the day? And unfortunately, the regulations have left some lack of clarity in this area. Some parts of the regulations suggest that the employer may require exhaustion of paid leave, similar to regular FMLA. Those of you who are subject to regular FMLA understand that if your policies provide for it, you may require the employee to exhaust paid leave before taking unpaid FMLA leave. And parts of the regulations and comments suggest that the employer may be able to do that. However, other sections suggest that the exhaustion of paid leave or use of other PTO, vacation, or paid sick leave can only be done when both the employer and the employee agree in advance that the employee will take the paid leave. So for now, until there's more guidance from the U.S. Department of Labor, the most cautious approach is to only provide for the use of paid leave to make up that 1/3 of a day with the employee's consent. Employer and employee can always agree that other paid leave can be made available to the employee to make the employee whole, if you will, for that full work week. But at this point, use caution before you're required to do that, pending further guidance from the U.S. Department of Labor. The eighth key takeaway is on record keeping. One of the key questions that employers have had because of the short time frame between when FFCRA was enacted and when it was implemented on April 1st, and the lack of regulations prior to April 1st, was what can we ask for from the employee as documentation, and what are we required to have in order for the federal government to reimburse us for providing this leave in the form of federal tax credits. And the regulations do provide considerable guidance on what you can and cannot ask for and what you must retain in your records in order to get the benefit of that tax credit. First requirement is for all paid sick leave or Emergency Family Medical Leave Act leaves, employers are required to obtain and keep documentation of 4 basic elements. 1, the employee's name. 2, the dates employee is requesting leave. 3, what's the COVID-19 qualifying reason for leave? And this goes back to the slide with the 6 available eligible reasons for leave. The employee has to tell you, I'm requesting leave, and which of the qualifying provisions of the FFCRA is the employee requesting leave under. And finally, the employee has to provide a statement that the employee is unable to work or telework because of the COVID qualifying reason. So if the employee is seeking leave, one of the key elements is in order to have paid leave, there has to be a reason the employee is unable to work or telework. And the reason can't be because the employer has no available work for the employee. If the employer has no work available for the employee simply won't be available to take paid leave. What additional documentation can you ask for? Well, that depends on the basic reason that the employee takes paid leave, as we'll cover in the next slide. Employers can ask for additional documentation, but that depends on, is the employee taking leave to care for a child or for his or her own illness? And finally, what record retention requirements are there? Well, employers must have at a minimum documentation of the above 4 elements in order to support leave in all instances. And that documentation must be retained for a period of at least 4 years in order to support and obtain tax credits. In the next slide, we'll look at what additional documentation may employers request depending on the reason for the leave that the employee is requesting. And employers must get that additional documentation, and they must also retain that documentation for 4 years as provided in the regulations. So number 9, key takeaway. What's the required additional documentation that you can and may request in order to support requests for leave and to provide a basis for your tax credits under the FFCRA? Well, again, that depends on what's the reason that the employee is taking the leave. In the left column, you'll see if the employee is taking the leave because the employee, him or herself, is subject to quarantine or self-quarantine or seeking a diagnosis, then in addition to the 4 basic elements on the prior slide, the employer is required to and able to ask for additional information. In the event of quarantine, the employer is required to ask for the name of the government entity that issued the quarantine or order, subjecting the employee to quarantine. If the employee is told he must stay home, then that would either be because of a shelter-in-place order or something similar, or because of a quarantine order due to the employee's exposure or illness, and that would typically be issued by a state Department of Health. You are entitled to and should ask for what's the governmental entity that issued that order. For self-quarantine, you are entitled to ask for the name of the healthcare provider who advised the employee to self-quarantine. As we previously covered, it's not enough that the employee, him or herself, just decided to stay at home or thought it would be wise to self-quarantine. The employee must have been advised by a healthcare provider, and you are entitled to request what's the name of the healthcare provider who advised you to self-quarantine. And in this instance, I recommend that employers ask for the specific name of the healthcare provider, not the name of the clinic or entity. So rather than saying it was Essentia Health, Sanford Health, or another independent medical clinic that subjected the employee to or advised the employee to self-quarantine, ask for the name of that healthcare provider and get that information. The same requirement applies if the employee is requesting leave to care for an individual who's subject to a quarantine or isolation order. You can and should ask for the name of that healthcare provider. What about in the right column when an employee is requesting leave for child care or school closing to care for his or her son or daughter, or to care for another? Well, in the event of a child care or school closing, you can and should ask for the name of the child. Secondly, the name of the school or the daycare or child care provider that closed or became unavailable. And I want to explain that a little bit. If it's easy to get the name of the school or documentation and the name of a child care center who is unavailable due to COVID-19. However, there may be instances in which an individual is providing child care and that individual is no longer available because of the individual's illness, vulnerability to COVID, or because of some sort of quarantine, isolation, or shelter-in-place order. In that case, you need the name of the individual and some statement that that individual is no longer available to care for the child. You need a statement from the employee that no other suitable person is available to care for the child. And again, if a co-parent, if a co-guardian, a grandparent, or someone has previously been caring for the child, typically that employee would not be eligible for paid emergency family and medical leave, because it's presumed that that individual is able to meet the needs of the son or daughter as he or she may have done in the past. And if the individual is in the home, the employee needs to explain why that person is not a suitable individual to provide care for the child. The fourth element is the explanation of what are the special circumstances required if the employee is trying to take paid leave to care for a child who's over the age of 14. And this applies during the regular work day if your employee works daylight hours. If the employee is working daylight hours and seeking time off during the day to care for a child over the age of 14, or says that the employee is unable to telework to care for a child over the age of 14, then the employee needs to explain what are the special circumstances that necessitate that. Again, is the child a special needs child? Are there other issues that dictate that the child requires greater attention than a typical child over the age of 14? Finally, if the employee is requesting leave to care for an individual who's subject to a quarantine or isolation order, then you are allowed and required to ask what is the name of that individual and what's the relationship of the employee to the individual for whom the employee is caring. If the employee is caring for an individual, as we discussed, there must be some relationship and some expectation that that employee would have provided care to that individual, and you are allowed to ask for some sort of statement from the employee of not only the name of that individual, but what's the relationship that creates the expectation that the employee would be the person to provide care for that individual. And finally, the new FFCRA regulations provide additional information on how can leave be taken. Can leave be taken intermittently in small blocks, or can it be taken, must it be taken all at one time? And the regulations themselves clarify that when an employee is teleworking, as opposed to when the employee is reporting to a job site and taking leave from a job that requires him or her to report to a job site, that flexibility is encouraged by employers, and intermittent leave is allowed with the employer's consent. So the employer, if the employee is teleworking at home and wants to take 80 hours of paid sick leave, the employer and the employee may agree that that may be taken in 4-hour-a-day increments. It may be taken in some other increment, so long as the employer and the employee agree on that. But when the employee is required to report to the work site, intermittent leave is generally not permitted, particularly if the leave is required to care for the employee or another individual's COVID illness or symptoms. And the reason for that is if an employee is required to take leave to self-quarantine, or because of his or her own symptoms, or to care for another in a self-quarantine or who has COVID-19 symptoms, the Department of Labor does not want to encourage that employee to be returning to the work site. So that 80 hours of paid leave that's available for quarantine or self-quarantine or to care for that individual when they actually have symptoms or are suspected to have COVID-19, that has to be taken in a solid 80-hour block so that that person's not returning to the work site and potentially exposing others to the virus. Finally, when the employee is taking leave under the Expanded Family Medical Leave Act to care for a son or daughter due to a child care or daycare closure, the Department of Labor encourages flexible working arrangements and the use of intermittent leave. Because of the employee's need to care for the needs of the child during the day, if telework is available, the employer and employee may agree on a flexible schedule in a telework situation, such that the employee is shifting hours and teleworking during hours that the child does not require care. Same thing is available if the employee is required to work from the employer's job site. Employers may agree with the employee's consent to a flexible intermittent schedule such that co-parents could shift hours. They could work, an employee who's regularly scheduled to work 8 to 5, for example, could work additional hours in the evening when not required to care for the child. So intermittent leave is available with the employer's consent in that sort of a circumstance in order to provide for the maximum amount of flexibility both for employers and for employees who are required to take the leave for the care of a son or daughter. Those are the top 10 takeaways from the FFCRA regulations. They don't answer all the questions, and in fact, even after the FFCRA interim regulations came out, the Department of Labor continued to publish and continues to update its questions and answers on the application of leave under the FFCRA. So again, I encourage you to get help. Although the regulations are out, they are interim regulations and they are subject to continuing interpretation by the department. So again, use the resources on your screen, particularly the Department of Labor FFCRA questions. The first link, that continues to be updated on a regular basis. Again, I'd recommend the Fargo-Moorhead West Fargo Chamber resources and COVID-19 updates. The North Dakota state government response updates continue to be updated. And please come to our website at vogelaw.com under our COVID-19 updates, where we continue to push out information on the ever-evolving situation and clarifications for employers of what are the requirements for handling not only this pandemic and its financial implications, but your obligations to employees and resources that are available to help you through this difficult time. Thank you for your time and attention.